Mastering Commerce workshop sessions, here and after sessions, are the private exchange of ideas and concepts between the providers and recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in these sessions is applied to the recipient's own personal transactions, cases, or controversies, or applied to other cases may or may not result in a favorable outcome or the same outcome as discussed in these sessions. Each transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transaction so that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subject being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions. And the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedures. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. These sessions may be redistributed privately by any recipient to another recipient requesting them, conditioned upon the fact that this notice is provided therewith. If you have any questions, you can contact Mastering Commerce by email at info@masteringcommerce.org.
Welcome. I'm excited about the information that we have to share with you this particular weekend. Myself, Jack, and Gordon, in the recent months we feel, kind of unlocked things to where we're having an extraordinary high level of success with processes, and I feel that there's a formula to this success. And what we're going to share with you this weekend is the formula, so that you can become the authors of processes that are effective. Okay? We will be sharing with you specific examples of process so that you can see how they work. How many people are new to this information? Okay, so we got a couple people in here. So we'll cover the basics over the next, at least today. I don't know if we'll cover, we may feel like you've been blasted into orbit tomorrow. I invite all of you who are new to ask questions. Okay? There are no stupid questions. But if you don't ask the questions, we can't create clarity for you, and you'll be lost when we get into day 2, day 3. You'll really be lost. Okay? So I invite all of you to ask questions so that you can be clear on the concepts, the foundation, and the principles, so that when we move into the materials for tomorrow and the materials for Sunday, you're keeping up. I also invite you to watch the video, familiarize yourself with our past work as well, so that you can get more of the foundation, because we can't cover, we could spend 6 days just on the foundation stuff for contract and law. But there's hundreds of hours out there where we've done work in foundation for you guys to get familiar. How many of you feel like you're well seasoned and very experienced in this? Okay. We had 0. So if we had levels of competency here, we have beginner here, and we have master here. Raise your hand when I get to about where you're at. Okay, all right, we got a couple. Here we go. We're about halfway there. All right, a couple more. We're getting down low, going towards beginner. Okay. What's the advantage, the power in being a beginner? What's that?
You learn something.
There's room for learning. There's room for improvement. So you notice how when I got down to the bottom of beginner here, Jack raised his hand. Because Jack knows that when you hold yourself as a beginner, there's always room to learn and improve. And if we didn't hold ourselves as beginners, we wouldn't be constantly evolving in our process as we have. If we held ourselves as masters, we'd say, no, we know, and this is the right way. And it's not that we didn't create success with how we were doing things 3 years ago. But we've had a lot more success with more inexperienced people as we've refined the process. So Jack or myself or Gordon may be able to have success with processes we were doing 3 years ago, but now we're having people who have as little experience as you having success. Okay, so there are some principles you have to understand. So what we're going to cover in these first couple sessions is foundation, principles of contract and law. So that as you, and you also wanted to do tying it all three areas together, okay? So, and what I'll do is I'll try to put that into the context of contract law and weeding it out. So, first of all, what is law? Law is contract, says who? Says Gordon. Okay. What makes law contract? Or what makes contract law? Consent? Is there law without consent? So how did you consent to the law? How did you form the contract? Did you sign something? What's that? Your expression. What do you mean by that?
The way you conduct yourself.
The way you conduct yourself. So does it mean you have to sign something to be in a contract? No, it's implied. For instance, you sit down at a restaurant to eat dinner. You order from the menu, which has prices listed on them. Did you sign something saying you would pay the price of the food at the end of the meal? No. But your conduct, sitting in the chair, ordering from the menu, receiving the food, eating the food, that's a course of performance. Okay, that's a term from the UCC. Course of performance. Through the course of performance, you have implied your consent to the contract.
Let's say you go into, let's say a confrontation, the officer does something against your will.
Okay, so you have a confrontation and something happens against your will, right? Is that what you're saying? Okay, so if I sat down at a restaurant to eat, but I didn't want to pay, is paying against my will at that point? Okay, so who's in honor and who's in dishonor? So you'd have to give me more specifics on the contract.
I think the officer, for example, give me
When we
information.
ask questions, we're going to pass a mic around so the recording.
Yeah, you guys want this for the recording.
Yes.
It's for your benefit, so raise your hand, wait for a microphone.
For example, if an officer pulls you over and he says, give me your information, and you don't want to give your information, but you don't want to dishonor, you want to...
Okay,
on the one hand, you're doing what he's asking you, but you don't agree with it.
Okay, now let's break down the contract, first of all. You're in a vehicle, right? Is the vehicle registered?
Yes.
Okay, so if the vehicle's registered, whose property is it?
The state.
It's the state's property. Okay, so you're driving, they're assuming you're driving, they don't know, but because it's a state-registered commercial vehicle and you're behind the wheel, they're assuming you're what?
The debtor.
That you're licensed to drive, right? Okay, do you have a driver's license?
Yes.
Okay, so you're in a contract. You're in a contract because of remember, it's conduct, right? You're behind the wheel of a vehicle. That's conduct. You're implying that you're under a certain set of statutes. Okay? Now, the statutes don't become relevant until there's this interaction that you're having with the officer, right? So they're totally irrelevant, immaterial, until there's an interaction. Now that there's an interaction, there's policy, right? The officer himself has policy, and you, as a receiver of benefits, as a licensed driver driving a registered state vehicle, have obligations. That's the contract. Okay? So the contract says that you have the obligation to be carrying a driver's license when you're driving a commercial vehicle, right? So another one of your obligations is that if an officer of the law or contract pulls you over and asks for said license and registration, you are to provide it. Now there's even statutes around proof of insurance, right? So based on the statutes, which you got into, you're in agreement with them based on performance, course of performance, course of dealings. Okay, that through your conduct, you're implying your consent to these contracts. So when I'm the police officer, I pull you over and I say, okay, license, registration, proof of insurance, and you start to impede or interfere with the contract, by refusing. Now, I'm not saying that there isn't some way to create a new contract, because contracts are what? Dynamic and fluid. They're always changing, they're always moving. So when the police officer steps up to your window and asks for driver's license, registration, and proof of insurance, what is that? It's a contract offer. What can you do with an offer? You can honor and dishonor it. And what are the methods of honoring and dishonoring a contract? You can accept it on its face. Okay? Which would be, what would that look like in this scenario? Hand them over, driver's license, proof of insurance, and registration, right? That's full acceptance of a contract. What else can you do when an offer is made? You could, well, let's not go there yet.
Silent.
You can refuse, right? You can decline the offer. Is that a form of honor or dishonor? It's a form of dishonor. Okay? So you can refuse and say, nope, I ain't doing it. Yeah, Terry.
Why is saying no dishonor?
Because you've implied there's a contract by your conduct. Okay? I'm not saying if somebody out of the blue comes up to you and goes, Terry, here's a lemonade. I'm offering it to you. And you say, no, that's not a dishonor, because you're not implying that you want a lemonade, right? Now, if you sit down in a restaurant and somebody comes up, can I take your order? That's an offer. And you go, no thanks, I'm not ordering. That's a dishonor, because you came into the restaurant and there's an implied contract when you sit down at the table that you're going to order food. Okay, so it's not necessarily that whenever an offer is made, declining it is a dishonor. But when there's an implication of a contract and an implication of an obligation, then it's a dishonor.
If you're already involved in some kind of either direct action or an expected action, like being in the restaurant, it's presumed you're not just wasting their table space, you're going to be a part of the consumer, then it would be a dishonor. Let's back up and make a couple of points on the question that he had and how Brandon resolved it. For instance, he said, do you have a driver's license? We haven't gotten to that point yet, and we'll teach you more about that, but you don't have a license. You're a living man or woman. A license is permission to do something that otherwise is illegal and unlawful. And the right of travel is definitely a right that living people have. But there are assumptions and presumptions. When you got the birth certificate, when you got the social security number, when you applied for driver's licenses, it's not for the living man or woman, it's for you in a corporate, fictitious point of view. So when Brandon is saying that if the law enforcement officer stops you, isn't he called a law enforcement officer? Substitute contract. He's a contract enforcement officer. He's there because there's a presumption that you, in the capacity of sitting behind the steering wheel in a state car, have a duty as a state party to have a license and to be doing some kind of business. So all he's doing is investigating this contract. He's enforcing law, enforcing contracts. And whether that contract directly applies to you in the capacity that you state you are operating at the moment is then conjecture, and it's going to come out based on the facts of your action, your statements, and your conduct. So if he were to stop someone and say, hey man, you're liable for the speeding ticket, well, you know, let's look at it this way, officer, forgive the straw man, forgive the licensed party. He really screwed up. how may I help settle this, you're not talking as the licensed driver anymore. You're talking at what we're going to go into this weekend as an accommodation party to help the law or the contract enforcement officer settle whatever the contract obligations are. And from the get-go, you've got to start thinking in your mind that you wear many different hats every day. You wear the hat of yourself as a living individual. You wear the hat as a husband, a father, an employee of a business, or the owner of a business. There's many hats you wear, and the outcome of what you're doing is going to be based upon the role you're playing at any given time in any given situation. So don't think of yourself as, I had the driver's license. There was a legal entity over here that was created that's separate and apart from you as a living man or woman, and that entity has certain contractual obligations.
And don't try to wrap your head around all this right now. Jack's really flying through this, especially for you new guys.
We're going to go back,
but we're going to touch on
foundation.
this. We're going to touch on who you are.
You want to get
and all
in your
the
mind,
things that you contract with.
You've got to get in your mind that you're going to play whatever role you are ready to play that's going to help you solve your problem. And don't think of yourself as just, I'm myself, I'm either a licensed driver or whatever. You're not. You are anything you want to be and any role that you have the capacity to play. So when you say, well, I got the driver's license, it was done for a specific legal purpose, and it's not necessarily you.
Okay? Yeah.
How would you know, you said there's an implied contract?
Right.
Like when you go into a restaurant or when you're driving a vehicle? How do I know when there's a contract? How do I...
Well, if you're doing anything and the things that you're doing happen to engage other people, other things, and if there's any kind of interaction, there's implied contracts happening. Human contact, human relationships don't happen without contract. Okay? None of them are written, but there's a lot of implied contract happening. So the fact that there was a contract when you applied for a registration of the vehicle. Okay? Now we'll get into this more because anytime there's an application and a registration and a certificate, you have a trust. Okay, so you created a trust. So it's assumed that you understand your obligations with regards to that trust. Then you went and applied, and they registered you and gave you a certificate for driver's license, right? Again, 3-step process, a trust was created. When you were born, your parents applied, registered, and received a birth certificate, right?
Yes.
Another trust. So each of these is distinctly a different trust. Then they applied for Social Security. You were registered. You received a certificate in the form of a Social Security card. Another trust. So wherever you see this process of application, registration, certificate, you have a trust that was created. And within a trust, you have several roles. You have the role of the settlor or grantor. You have the role of the trustee or trustees. And you have the role of the beneficiary or beneficiaries. And each has duties, obligations, and responsibilities with regards to the trust.
In essence, when the law enforcement officer stopped you in an automobile, which was the example that we're working with, your immediate reaction was, I did not ask this law enforcement officer to stop me. He's keeping me from going to the party or going home or a business appointment. I don't want to engage him. I don't volunteer. The problem is he did not stop you just as an independent, isolated event. He is enforcing contracts or trusts that he presumes exists in the background, to which you've got, like Brandon said, duties and obligations. And so it's not the speeding ticket that he stopped you for. It's an infraction of a contract that you had way back in history that you probably don't even realize was contractual obligations. And he's enforcing something that existed maybe decades or years ago in your life. And you're saying, but I don't want to volunteer right now, officer, so go away. That's a dishonor because you don't understand. He's investigating something that you had something to do with, that you don't understand the consequences thereof. And because of that, it's a dishonor on your part to say, I don't want to volunteer, because he's enforcing something that's already in his mind in full force and effect. The first thing he says is, may I have your driver's license? He has to identify you as a U.S. citizen, a state resident, which leads back to the birth certificate obligation trust, the Social Security trust, the application for the license trust, and he's enforcing provisions of multiple contracts you're already involved with. And you say, I have an unlimited right to travel. Maybe as a living man or woman, you have an unlimited right to travel if you can play that role. But if you come back and agree with him that you're under that birth certificate trust because you're a U.S. citizen, or you're a state resident because the driver's license proves it, then you are the party playing a role in this trust that has a duty and an obligation under a penal contract in the public policy, and that's why he's on your case. So everybody has unalienable rights, but everybody also has duties and obligations. Scripture says whatever you've put your hand to do, that you will do. So what Brandon is saying is you may not want to play the role of the licensed driver fiction. You may want to play the role of the living man. But because you were involved in getting that straw man a driver's license, a birth certificate, and everything else, and you haven't resolved that, at least you owe the contract enforcement officer and his principals the duty and obligation of paying the fine on whatever he's charged with, because that's what they have an expectation for. So like Brandon told you when we started out, we've got all kinds of remedies for you. But you don't want to argue with any of these people because you've got contracts and obligations that probably most of you are totally unaware that you have. And it's all of that baggage of everything you've done in the past. In one sense, it's baggage. In another sense, it's a huge blessing when you can see what they have done for you and your estate. But you just don't want to get in an argument or a dishonor with these people. Help them do their job and understand who you are, the baggage you're carrying with you, and what you got to do to resolve your straw man's problems and then your problems as a living man or woman. And you got to think in this taller area. And later on, I'm going to go in and I'm going to open the picture even more for you, because right now, the corporate U.S. as a profitable government is pretty much thumbs down, gone. And this concept that I am here to save the United States. If you define the United States as the profit-making corporation that we've been living under since 1933, it's pretty much toast in history. But the United States of America, the landmass, the people, the unalienable rights, those are something they cannot get rid of. But you have to see bigger pictures, and you have to understand where you fit into it, so that when you formulate your remedies that we're going to show you this weekend, you're on the right side of the picture and you're not contrary to the law. I mean, to your contracts.
Go ahead.
By the contracts, you mean there's trusts.
Trusts are a form of contract.
So when there's a trust, you can act either as a beneficiary, a trustee, or...
We'll probably get into that and define what they are. What Brandon's telling you is contracts can be made really in three ways. One, meeting of the minds, and that can be in writing, or it can be oral, or it could be implied. The second one is by your actions. There may be nothing in writing. There may be something in writing, but your actions will determine what's going on. And finally, your conduct. So you can have a contract in any one of those. And the problem that you're having in the court is you go in and want to explain why you think you're right, and the judge and the prosecutor are going to engage you into something whereby your speak in the court, your actions in the court, and your conduct in the court betray what it is that you're trying to tell the court means you should enjoy the success, and they'll get you into a circumstance in which your actions or your conduct say, but I'm not right, you're right. And they will get you to give up your contract by your actions or your conduct.
Contracts are always dynamic and fluid. So even if a contract is, really it comes in two forms, like Jack said. It's either expressed or it's implied. And if you come in with an expressed contract, they can very easily shift that contract by implication based on your conduct and actions. Okay, so contracts can always shift and change. And that's something that has become immensely important and powerful in having success in what we're doing. Okay? Because what we're looking to is, if you want any kind of enforcement or ratification in the public, you're dealing with a court. And when you're dealing with the court, it's an open market. Contracts are constantly being shaped and executed and enforced. And if you're not savvy to the principles of contract, you'll lose your contract. Because we'll share with you methods of expressing a contract, but if you're not familiar with the principles of implied contract, you can lose your contract like that. So you'll learn effective ways of expressing a contract and effective ways of keeping your contract.
Implying.
Through your conduct and actions. So that your conduct and actions match what the express contract are. We haven't even got to the third thing we could do. Go ahead.
Actions and conduct seem pretty similar. Could you define those, please?
There's it's not meant to be made a specific distinction, but actions typically would be deliberate. You know, like, I'll give you an example.
Let me define it this way, if I could, Brandon. Everybody knows that when you create an entity, Scripture says you need 2 or more witnesses to make anything known. When you go to create a government, people have read the Constitution, and you see that they're creating a 3-part entity in the government. They're creating a legislative body, an executive body, and a judicial body. The legislative body is really, in contract, your written or oral agreement. It's the meeting of the minds between the 2 parties. And you have to have that meeting of the minds before a contract exists. Once you have the meeting of the mind and the contract exists legislatively, see, the legislature passes the written laws by which the policy of that corporation is known, and everything operates under those written laws passed by the legislature. The executive cannot create its own law. The judicial cannot create its own law. So, in the legislative capacity, in your contract, the meeting of the mind you have with the other party creates the contract. The executive enforces the contract. And so it's the action part of whatever's going on. The legislature does not go out and it does not charge somebody with violating its laws. It's the executive that does that. So that's the action. So it's your acts or action, which is your legislative portion, dealing with that contract obligation between the parties. The judicial doesn't enforce the laws by charging. The judicial really goes back and it takes a look at the legislative. What was your contract? And then it takes a look at the actions of the parties to see if the actions are in harmony with what the evidence of the contract is. And that's what the executive does, but the judicial says they say they agreed to this. What did their actions look like that was in harmony with what they said they agreed to? And then the judicial, that is the conduct, because the conduct is the agreement between the parties and the actions that they all did to reinforce as a second witness that that's what they agreed to. So you've got the contract, the acts and actions, and the conduct. Conduct is really looking at the actions in light of the evidence of what the contract is, whereas the actions is just what they did on a day-to-day basis, either performing the agreement or violating the agreement. So it looks like conduct and actions really are the same, but conduct is the judicial interpretation of the actions as it applies to what they say the contract is. Does that help explain it?
How about like a conductor? The music's already written, right? And you have the actors, the ones playing the instruments. The conductor sits separate from the music and the musicians. Okay, so the music's like the legislation, musicians are like the actors, and the conductor is doing his best to interpret the music, right? And that's the judicial's job, is to interpret. That's it. They're just here to interpret the music and what the musicians are doing. And if it doesn't seem like it's that it's in line by their interpretation of what the music says and how the musicians are playing, what are they doing? They're giving you signs and signals to correct you. Bring it up, bring it up, bring it up. Take it down, take it down, take it down. Hit here, hit here, hit here. You see?
Look at it another way. In the public courts, a lot of times, particularly patrons, say that a judge is practicing law from the bench. But remember, the judge is there kind of like Brandon says, as the conductor. He didn't write the music, and he isn't playing the music. He's just interpreting how the players are doing with respect to the music that was already written. Now, you might say that the judge is writing law from the bench if the judge makes a decision in a case that you don't have the right of free travel. But there's plenty of case law, particularly prior to 1933, that says that people do have the unlimited right to travel in the mode of conveyance of the day. So why would the judge state that you were in violation of the driver's license statutes and provisions of the state, and you owe a fine when you came into court and you tried to use the defense that I am a living man and that I have a right to travel in the mode of conveyance of the day? And the judge finds your straw man guilty, but you don't realize it's your straw man. You think he found you guilty, and you say that he is now legislating from the bench. No. His job is to interpret between the contract and the performance. He's not legislating saying that living people don't have the right to travel. He is applying your contractual obligations when you applied for the driver's license. And when you came into the public tribunal, he's merely interpreting the public contracts that you've got out there as it applies to you today. So the judge really isn't legislating. He's looking at where your contracts are. And remember, every time you sign or perform a contract, isn't that diminishing your unalienable rights? Because in every contract, it's a two-way street. You have to give up something in order to get something from someone else. And so you're always losing your rights when you engage in a contract. And it's not that the judge is preventing you from losing your rights. You lost them when you went into the trust and exchanged something, freedom and liberty, for some kind of a benefit. So the important thing for you to understand is contracts change everything you're doing in your life and the expectancy of what you're going to get out of that contract or what you have to pay for having entered into that contract. And so the whole idea is to understand you're in contracts. They create relationships. The other party has an expectation that you're going to provide to him what it is that you granted when you got into that contract. And so if you don't want to perform under the contracts, know what's happening and don't get into them. Once you're in them, you got to perform. You may not have to perform as the straw man party in the contract, because today in Admiralty High Seas law, which we're all in, it's the straw man that's doing that contract, and you've got the ability to stand apart from your straw man as an accommodation party and to help get him out of his problem and trouble as long as you can resolve the other party's issue. That's why we're here this weekend. Understand what you're obligated to do. Understand that you're not just performing as one legal entity. You've got me, myself, and I. And all three of those are distinct legal characters that have a role to play in commerce. And if you're going to play me all the time, you're never going to win, because he is the loser, the defendant, the debtor. If you play the myself or the I, you've got a prayer of a chance of making it if you understand what that is and where you can hold it. Okay, so let's go back to our foundation and our basics so that everybody sees where we're coming from. But you can see that these all are going to have higher implications in trying to get our remedies.
Okay, so there are three ways that you can respond to an offer. You can accept it, you can decline or refuse it, or counteroffer.
And what does the effect of a counteroffer have on an offer? Okay, that wasn't on the mic, but Brandon will repeat it for us.
Okay. The effect of a counteroffer is that the original offer is taken off the table. It is no longer part of the contract. So for instance, I offer Becky, I'll give you $1 for that coffee. And she comes back at, give me $2 and I'll give you the coffee. The $1 for the coffee is now no longer a viable offer. There's a new offer on the table. And I can either accept, decline, or counteroffer. So I can say, I'll give you $1.50 for that coffee. What's that do to the offer of $2 for the coffee? Takes it off the table. What do we typically know this as? Haggling, negotiating, right? Counteroffer, 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 offer, counteroffer, right? One of the most amazing things I ever saw was a reenactment on History Channel of the armistice, the end of World War I. They had about 4 or 5 German politicians who came to the Allies wanting a ceasefire, a benefit, right? And they had one French general representing all the interests of the Allies. They were together in a room, and the French general just sat there. He just sat there. And the German politicians were just sitting there, kind of looking back and forth at each other, but nobody was about to make an offer. Because really what they were there to do was to petition. They were there to request, like receiving a benefit, which would have been like you when you applied for Social Security, or you applied for a birth certificate. So neither party wanted to be the party applying, because it gives them no power in the trust, right? When you make the application, the person receiving the application becomes the trustee and has all the control. So you had these guys, this is on the History Channel, it was amazing, amazing. You should look it up. It was I don't remember what the episode was called or anything, but it was about World War I, about the end of World War I. And so the Germans are sitting there, and they try to strike up a conversation without making a direct petition. You know, we heard from that the President of the United States has offered, a settlement. So they're trying to imply that the Allies were the ones petitioning for the end of the war. And the German general sat there and goes, "We're perfectly happy fighting this war till the end." Basically saying, we're not here to petition for anything. Is there something you want? What do you want? What are you here for? And then that finally came out, they requested a ceasefire. So they petitioned, they applied, they requested. The Germans. The Germans petitioned the French general for a ceasefire. The French general says, "I accept. Here are the terms." And that forever became what led us to World War II. Because the French general bent the Germans over and gave it to them good. Took away every right they had as a sovereign nation, right? But it was because a trust was created. I mean, clearly in this video, this French general was a contracting master. He was a master. He knew exactly how to run the contract. And he was dealing with 4 or 5 lawyers. He's just a general. You have 4 or 5 politicians all trained in the law. And he understood that breaking it down to its simple components, someone came and applied. They made a request. They petitioned. So a trust was created. He accepted the role as trustee and said, here's the terms and conditions under which we will provide that benefit of a ceasefire. And so those were the terms. And because they came and petitioned, because the Allies didn't offer a ceasefire. Had they offered a ceasefire, then there would have been more negotiation, right? But he stood in the position that the Allies were perfectly happy to fight this to the end. We're not seeking a ceasefire.
You've got that same condition in the court scenario. If your straw man is being charged in a criminal case, didn't they make him an offer? You're absolutely in the best possible position having your straw man charged being the defendant. If you understand what Brandon just told you, they've made you the trustee for settlement. And you've got the complete authority to handle this matter. When the law enforcement officer rolls up to your automobile and stops you presumably on a traffic citation, isn't he making you an offer, and aren't you being made the trustee to handle the matter and resolve it?
Now Jack's speaking into specific roles here. Okay, so let's try to identify the roles that he's speaking about. Who was charged? A corporate entity. We oftentimes call it the straw man, but in essence, it's a trust. Okay, so we're going to call this, because you guys are familiar with it, the straw man.
Straw man is just a front. In The Wizard of Oz, it was the scarecrow. He was always being picked on.
Okay, now he's saying that you're in the same position as the French general. Does that mean that the straw man is in that position? No, because who are they petitioning? Are they petitioning the straw man? No, they can't. The straw man can't do anything, can he? Can a stack of papers do anything? Because that's all the straw man is. It's made up of a series of documents. Birth certificates, social security cards, all just instruments and documents. They, in and of themselves, can't do anything.
In Brandon's example, they weren't petitioning the French general, or they weren't petitioning the politicians of Germany. They were all playing the role of an agent or a trustee or somebody that was going to do the business of the French or the Allies or the Germans. See, a name is just something to distract you from the business. You are who you are whether you had a name or not. You're living. You're a breathing soul and spirit, and you have the capacity to cause things to change. The name is a dead thing. It can't change anything. The name represents the pile of paper calling itself a legal entity. That's all. Everybody's dealing with something that's alive, even though it appears as though the business is going through something that's a dead thing that has a name to it. You got to get beyond the name. You got to get beyond the dead thing. You're living, so therefore you have duties and obligations to settle problems, and that's what we're here to do. Who's got the problem? How do we settle the problem? So what Brandon is basically telling you is the straw man is a name, it's a fiction, it's a pile of paper. But on the high seas of commerce and admiralty, they pick on the name, they don't pick on you. You belong to God. They would not pick on God's people. They created the name. They created the fiction. They're picking on their own creation. And you have the ability to move into God's world of living and solving everybody's problem, or attaching yourself to the dead thing they created, thereby going down the tubes because you're on the side of the dead instead of on the side of the living.
Now let's look at what created this entity and what are the duties and obligations that surround it. There was an application. Who made the application? The parents, right? Typically mom in maritime. So the parents have something to do with the creation of this entity. If it were a trust, what would the parents' role be? Grantor? Okay, who else is involved in this contract? Who did they make the application to? State. So the state's involved. What did they make a granting of? What was the corpus? What was the property that was placed into trust? The body, the baby. Right? So any contracting with this entity could involve any of these entities, right? Now the grantors at a certain point fall out of the trust and any involvement with it, don't they? At what point did this party no longer have any obligation in regards to this contract? Once it reached a maturity date of 18, right? Just like a bond matures, the trust matured at 18. So at 18, there's no more duty or obligation with the parents.
Actually, the parents were the stand-in for you. And so when the trust matures at age 18 of the corpus, the body, you have become now basically the grantor by your failure within 30 days to rescind the trust.
Did you hear that? Okay. The parents were acting in your behalf to create the trust because did the body belong to the parents? No. It was yours. However, it's determined that you're incompetent to contract until you're 18. So when you reach the age of 18 and you, through your conduct, through your actions,
Or lack thereof,
reinforce this, the creation of this trust by not rescinding it. You're old enough to contract, you've accepted the role, you've accepted the benefits, and therefore, through implication, you've implied that this trust shall remain in full force and effect.
Now, the birth certificate and the Social Security app are two different things, aren't they?
Mm-hmm.
Understand this. Maybe your problem wasn't the BC, but why did you have to go out and do a Social Security app? What did that do to the trust? It registered it to do what? It was already registered as a trust. What did it permit the trust to do? Business. In commerce. Not that the other parties, particularly the state, were not already using it privately in commerce, but when you apply for the Social Security number, don't you need that number to do public business? So now you are putting that trust in public business, and depending upon how you applied for that Social Security trust determines the relationships of the party for attaching this trust to public commerce. So they don't do anything by accident. See, if you go out and apply for a driver's license, what do they want to have as proof that you're entitled to the driver's license? Birth certificate and Social Security card, if what?
If you have one.
If you have one. And then they're going to look at the application for the Social Security card to see what capacity you enrolled to do business. Did you understand that there's more than one capacity to do business? And chances are, like everything else in your life, you screwed up and you registered inappropriately to do commerce under your BC trust.
Well, you signed up for a franchise. That franchise is known as a U.S. citizen. You were not necessarily born a U.S. citizen, but as soon as you, and a lot of times now with the new birth certificates, there's actually that election for U.S. citizenship on the birth certificate as well. But as soon as you applied as a U.S. citizen on the Social Security registration, you're signing up for benefits and privileges, right? There was an application, there was registration, and you get a little what? Certificate that entitles the bearer to what? Benefits and privileges. So it's like a certificate of beneficial interest, isn't it?
But it depends on how you signed up. So you could sign up, isn't this a trust we're talking about? And what are the three roles, basic roles in a trust? Grantor, trustee, beneficiary. Who told you you had to sign up as a beneficiary? Didn't they tell you you could sign up as a trustee? What's the difference? For instance, most apps for the birth certificate, who is the trustee in this trust then, to begin with? The state. Why? Because the object of the trust, little baby Joey, has no legal capacity to do commerce until he's 18. So he is a beneficiary, either of his parents or the state, until he's 18. But after he's 18, then he could go to be the trustee if he chose to be so, or he can elect to stay a beneficiary. The same thing's true under Social Security. They make you choose, and then the government assumes the other role. If you choose the role of beneficiary, what does that make the government?
Trustee.
Trustee. Who has the legal authority in the trust? The trustee or the beneficiary? The trustee, he's the controller. which is why you're under the driver license statutes, under the housing building code. It's why you're paying income taxes in part and everything else, because you chose unwisely as a beneficiary in this trust instead of the trustee. There was another way of doing it, and you just followed the leader of everybody going over the cliff as a beneficiary, and you didn't understand you have options. So you could sign up for a Social Security commercial relationship to this account and be the trustee. Gee, if you did that, do you think the outcome might be different? The answer is yes. And you could hold it.
You don't have to have the account.
You don't have to have the account either.
You don't have to be a part of that trust at all. That is an option.
When you turn 18, do you have like a window there to...
30 days, generally in Commerce.
Okay, how do you know that? Like, where is that written, or where is that?
It's part of the foundation for anything you do. There's timetables in Commerce for everything.
Like when it matures, there's a window to go back and make some changes?
Does that mean it's hard and fast? Not necessarily.
No.
It depends on what role you want to play and whether you're going to resolve the problem as the trustee or the one with legal authority, or whether you're retaining benefits. There's a time you want to be a beneficiary in certain things in life. There's a time that you need to be a trustee, and knowing the difference is critical.
If you choose not to partake in it at the age of 18, then is the trust dissolved, or what happens?
It doesn't go automatically. If something's created in a fixed relationship, you got uncreated. For instance, anytime a certificate is issued, how do you collapse the trust? Return the certificate.
Just like with the car registration, right? You get a certificate of title on the car. Now, typically, it's only ever collapsed when you're selling the car. But what do you have to do with that certificate of title?
Endorse
you have to turn it over and endorse the back, right?
Remember, the front of a piece of paper is the public side. The back of the piece of paper is the private side. So if you want to take it from public, state ownership, to private, you endorse the back, thereby discharging all debts and bills that the public has liened the property with, and now you've returned it to the private.
Now, it remains there for all of about 5 minutes. The car is free of any state control. But then what happened is you gave that endorsed certificate to the buyer. And the buyer takes this endorsed certificate down to where? Department of Motor Vehicles, or whatever it's called in your state, right? And does what? Well, first he gives notice. This trust has been discharged.
That's the one you were in.
That's the one you were in. But on that same document, there's a little place for him to fill out and apply for his own registration, right? So DMV person goes in and cancels your trust. Boom. Property's free. No state control. And then she processes the application for registration. And now it's back under state control. So for all of 5 minutes, that property was free of any state control.
Which is why the new guy's got to go out and get his license for it, yada, yada, yada.
So can you...
Up here.
So can you do the same thing with like the BC or Social Security account?
Idea, but then when you endorse the BC, who do you turn it into? And after you turn it in and the property is no longer registered under that trust, what do you do to make a living, to go on with your life, to be able to put bread and butter on the table, to be able to get on an airplane and fly away on a vacation? Are you going to have a problem opening a bank account when the tax guy comes around and says, hey buddy, I haven't seen your tax return? How are you going to talk to him? What are you going to say? Because remember, contracts are dynamic. They do not need that birth certificate paper to assume and presume you have duties and obligations. And so if the tax guy comes around and says, hey, buddy, I don't think we got a tax return from you last year, and you do anything in dishonor, you've got a legal obligation even though you don't have a birth certificate of trust. So you have to understand how to handle your affairs, because otherwise you morph these contracts, and whether they actually exist in writing or not, they change with your actions, your statements, and your conduct.
So is there anybody here who feels they're at a point where they can operate in commerce free of the United States? Would you want to? Not necessarily. You know, in reality, if you completely destroyed these entities without creating some other entity through which to conduct business within the United States, and I don't mean within the physical boundaries. What do I mean by within the United States? Within that jurisdiction.
Their commercial system of employment, banking, bill paying, credit cards.
If you want bank accounts, if you want to deal in Federal Reserve notes, if you want to travel, you're going to have an entity through which access to that system is available. Now, I'm not saying it has to be a U.S. citizen. It doesn't have to be. It could be a non-citizen national. It could be alien resident. It could be non-resident alien. There's all types of status for different entities. And you could, like me, I conduct most of anything that I'm active in within the United States is through some other type of entity, not a straw man entity. Various trusts, corporations, things like that. LLCs. Those are the things that I choose to operate within the United States through.
Foundations, corporate souls.
You said there's a
We need one back here too.
beneficiary, grantor, and trustee. How do you know when to be each one?
Each one has his own conduct and action. A grantor is someone that creates the written document, which is the role, he's defining the role that the trustee and the beneficiary are going to play. And the grantor is the one that conveys some piece of property. What is property? Isn't it a collection of the rights and duties? So property is not necessarily this carpet or the land. Property is something you can describe that has rights and duties associated with the use, conveyance, and whatever thereof.
I would say property is anything that a security interest may be perfected in.
So a grantor has something in mind. It may be Federal Reserve notes. He's got a pile of them, and he wants to convey it to his children outside of a will so that he can do it himself. So he puts it in trust. He appoints a trustee. That's going to be a manager that is going to do everything he asks them to do in this writing. And he's going to say to the manager, I don't want you to give my kids all the money out in front because they're going to waste it. It's going to harm them. They're not going to be able to take care of it. So I'm going to write in this trust that you have the duty that every month you're going to give each one of my children $1,000. And no matter what they yell, scream, you're bound by this contract just to give them $1,000 a month. So the trustee has got duties and obligations placed on him by the contract that the grantor has written, and that contract shows how the trustee is going to control, use, manage whatever property is put into the trust. It could be money, it could be a house, it could be a business, it could be a number of different things. The beneficiary, he gets the benefits of the trust, but he cannot dictate in what terms and conditions they're going to be. That's fixed by the grantor in the trust, and the trustee has a duty to only do those things that he's been given authority to do. And the beneficiary can yell, scream, jump up and down, and he cannot change the trust. So if you're a beneficiary, you can yell, scream, and jump up and down as to the way things are doing it, and it won't make any difference. But as a beneficiary, you are entitled to whatever you're entitled to in that trust. And if you're not getting it, you can jump up and down and go to court and make a judicial court compel the trustee to live under the provisions of the trust.
Now, the trust and the roles of grantor, trustee, beneficiary, a lot of times when you're the one making application, you take on a role of grantor beneficiary. Okay? And there's also an important factor of trust is revocability. So for instance, when you as the possessor, controller of a car, place that car into trust with the state, you become grantor beneficiary, state being the trustee. There are two titles. See, trusts create what's called a split title situation. There's equitable title and there's legal title. So whenever you have a trust which has grantor conveying property to a trustee for the benefit of a beneficiary, the title, let's say this is our property here, the title of that property is split into equitable title, which is held by the beneficiary, and legal title, which is held by the trustee. So before the title was split, there was one title. An unsplit title we know as allodial title. Now this process of property being placed into trust, held by a trustee, title being split between the trustee and the beneficiary, happens so much in our society that it's ridiculous and really mind-boggling to keep track of every time this happens. Because it happens with every transaction. Every single transaction involves this process of title getting split. So it's splitting and then splitting and then splitting and then splitting and then splitting again. These are forms of security interest. Now, with the case of the vehicle, is that a revocable or irrevocable trust? What is it? Revocable. How do you revoke it? How do you give notice? You just endorse the back. Who has the right to revoke it? The beneficiary or the grantor? Actually, the grantor. But you're both, aren't you? Or the straw man's both, grantor and beneficiary.
If you had all the power, would you be in the grantor or the beneficiary position? Grantor, because you had both legal and equitable. Understand, legal means the right to determine how you can use it.
Control.
It's control.
It's control
over
of the property. Legal title is control.
And equitable means you get the benefits. You possess it and you use it. But it's like you're a renter on the property. You're in possession and you're using it, but the actual owner of the land supposedly is in control of it. Now he's given up the right of possession for the duration of the agreement on the lease agreement, but he's still in full control because he gave that up voluntarily in return for monthly payments. But if you, as the beneficiary of that lease, possessing and living in the house, stop making the payments, you're in violation of your terms of being the beneficiary, and then he can go back to court and regain possession, which is the obligation and right and duty of a trustee or one who's in control.
So let's look at real property for a minute. What's being bought and sold in the real estate market? Equitable interest in the property.
Possession and use.
Only the equitable title. Because where's the legal title at? With the state or county, right? So all land, most land in the United States has been placed into a trust. And the counties and states are acting as trustees over that land.
Why does the state have the assumption of being in control on all land sales? No one's claiming it. Why is no one claiming it? Didn't you buy it?
You didn't even acknowledge the title.
Well, that's the form of it, if you follow what he just said. Look at it this way. You heard the adage, you get what you pay for? What did you buy the land with? Federal Reserve notes, which are mere promises to pay something. How can you have paid for it if you only gave them promises and not the payment?
Right.
And so the state is assumed to be the legal title holder in all purchases of anything, not just land, television sets, the clothes you're wearing on your back, you name it. They assume to be legal title controllers because the assumption is you never paid for what you bought. All you gave them was promises to pay. And so the state is not truly the legal title holder. It's just assumed to be the legal title holder as a fiction of law. Because they know since 1933 that presumably you did not ever pay for what you got. And the state assumes legal title through the legal process of escheat. E-S-C-H-E-A-T. And escheat means that if nobody can prove legal title, the state assumes legal title as the guardian or the trustee for the actual property title holder, waiting for the real property title holder to show up. So the presumption that the state has a controlling interest as trustee in everything is based on the disability of our current public money system to give you a remedy, unless you know differently, and we can show you how to access a remedy if you so choose to use it. But it's a rebuttable assumption. But what Brandon is telling you is that anything in public commerce today is done via the presumption of a trust, where the government is the trustee having legal title, which means it can dictate how you drive the car. You've got to wear seat belts. You've got to keep all of the turn signals working, the hazards. You've got to have a minimum inspection for safety, because their duty as the trustee is not the trustee liable for anything that happens to the property in the trust? You bet. So if you're out there on the highway and you get into an accident, who is the one that's ultimately liable?
Trust.
The state. It's their property. Do you think the state wants everybody to know that?
Right.
Do you think the state, even in its current condition of disability and economics, can handle resolving all of the accidents and all of the lawsuits resulting therefrom? No. So what do they make you as a beneficiary do? They make
Get
you
insurance.
carry the insurance. Did you think that was to protect you?
Go ahead. And now what are they trying to obligate you to
Testing
get
1, 2.
insurance on?
The body.
The body.
The body.
More of their property.
Say, how would you remedy a situation where you have a vehicle, but you never register it after setting up financing for it, and now you're getting these notices saying, "Hey."
So there was finance. It's financed,
It's-
meaning
it's being
so you don't
financed.
you don't actually hold the
legal
MSO
title.
on it or anything.
No, sir.
Okay.
And you're getting these notices in the mail saying, "Hey, you need to come down here and pay this money to register it." and then you're getting tickets saying that you haven't registered. How would you?
Absolutely.
How would
Whoever's
you?
carrying the financing on it actually holds a certificate of title. What do you
Well, no. They hold the MSO at this
The
point.
MSO, right?
The MSO has been, because there is no certificate of title yet because you haven't registered it with the state.
Right.
Right?
Okay.
So, but what the financing company did was they sent the MSO to
The DMV.
the state.
Oh, the state. Okay.
So the state is actually holding legal title because they hold the MSO, and they're saying, hey, come down here and sign up for the benefit. We need to know who our beneficiary is. But they control the vehicle. Don't think that they can't show up and take it because they're holding the MSO.
If you actually, in one of your many capacities, actually paid the equivalent of lawful money for that automobile, nobody would be hounding you. But because you didn't pay for it, you're not entitled to it until you do. It's basically stolen property. The reason that they want you to come down and register is because if they're going to allow you to have possession of property that you didn't pay for, they need to hold a security interest so that they have a cause of action to understand that you're going to cough up the payment either in equity or in law, one way or the other down the road. So basically, this is your notice that you've stolen this property. You have no rights, titles, and interest in it, no matter what you think you've got in your mind, because you never paid for it. And so you're either going to come down and register and give them a security interest so that they will permit you as the beneficiary to possess and use the car as you make even the equitable payments. Or else it's going to get mean from here on out because they're going to treat you like the thief of property that you're not entitled to.
And that's why the bank gave up the MSO. Because the bank was entitled to hold the MSO. So they had controlling interest. But why does the bank not want that controlling interest? Because bankers aren't as intimidating as sheriffs. Right? Plain and simple. Bankers are going to have a real hard time enforcing that contract, aren't they? But when they can call up the sheriff and say, hey, we're going to have this car towed, will you protect our property and make sure that it doesn't get damaged or anything else? The sheriff goes, well, let me see. Yep. Looks like the state has control of that vehicle, so the state has an interest in the vehicle. So yeah, it's my job as the sheriff to go out there and protect the property. However, if the sheriff goes through and says, oh, we have nothing here. We don't have an interest. So no, you handle it, Mr. Banker. It's your property. Handle it. Right? So now the banker's got to go out there. He doesn't have a big tough toe man with him. He doesn't have the sheriffs with him. He's got his suit and tie on. And he's got some redneck with a rifle coming out, get away from my property. It's not going to be as effective as having the state handle the situation for him. So the state got involved when the MSO was sent to the state. Now, you could have gotten the MSO. In fact, this is an interesting little hiccup that's come about lately. You guys have seen all those shows where they build motorcycles for people? Right? Well, guess what? There is an MSO. It'll be whatever they create for you, but there's no VIN numbers, right? So basically this is free. These are free vehicles, free of any state control. In fact, one of the guys who had bought one of these motorcycles from Jesse James, the guy who builds motorcycles, he had bought a Jesse James motorcycle and was fighting with the state to get it registered. And they wouldn't register because it didn't have a VIN number. But he was fighting them to try to get it registered. Like, take my property, take my property, take my property. And they're like, no, see, for us to take the property, we got to be able to track the property. Right? Because as a trustee, I got to know, where's my property at? And those VIN numbers help them to identify the property. So if Jesse James created an MSO for Mr. Guy who wants to give his motorcycle to the state to take down to the state offices and file with them, he'd probably have a little more success. But something that the state is looking for is a unique identifier. Now, it could be as easy as Jesse James filling out a UCC form because he was the manufacturer of the motorcycle, right? So he has the original interest. He registers his interest in the bike. And he uses that UCC filing number as the vehicle's identification number.
On the private as opposed to the public side.
Right. And then he could assign the interest with the UCC3 to the guy who he built the motorcycle for.
Now he's got a private interest in the property.
And so now they've got a private registration of the vehicle and a claim to the vehicle.
And if he wanted to register it, he could probably do a UCC3 assignment to the state.
Yep.
Okay, we gotta talk about that later on.
About what? UCCs?
Well, yeah, getting registered. Well, having a private interest.
Yeah, it's really not a very complicated. Yeah, we don't want to start on that right now. We will. You know what?
It is part of what Brandon is saying. Everything is a trust. But there's public trust things, and when they're doing things in the public as a trust, you never see it as a trust. You just say, oh, we're registering the vehicle. It is a trust, but they've statutized it publicly so that it doesn't appear in your thinking as though that's a trust. You see it as, oh, that's something the state requires, I've got to do that. Well, the only reason you have to do it is because you choose to be part of it.
Here, let's go around quick and get the questions, then we got to take a break.
Going back to something.
Do you have a microphone?
Going back to something Jack was saying about the redemption process and stuff, generally speaking, is there a deadline for that? You were talking about in Boston 2010, 2012, shit hitting fan and things. Maybe there being a deadline to be able to do that.
Yeah, we'll talk about that more this weekend. Yes and no. Remember, they never take away your total unalienable rights, except
and
with
contracts are always dynamic
with your authority. But there are, in the public, there are always windows of opportunity based upon time for which the public automatically authorizes things to be done. But the way we have been seeing things happen is if in the private you understand who you are and you're resolving the problems. Time is a fiction that only applies to other fictions. Because we know in Scripture it says that the past, the present, and the future are all one. There is no such thing as basically a time change, because what was, is, and will be. And so if you've got unalienable rights, you can probably get around that. But if you want to do things that the public is automatically going to recognize, there are timetables and you should be aware of them.
Who's got the microphone?
I have a question. So the state's responsible for damages that exceed the limit of the insurance policy, is that correct?
They might be.
And how would you approach that? With an administrative process?
You have to know who you are and how to move your process. Most people are having trouble just keeping from getting in trouble, let alone going out and trying to get remedies for things they're entitled to, but they may not have believed they were entitled to.
And neither the state or the insurance companies are giving up the game. So unless the parties involved in the contract know this, neither the state's not going to step up and say, oh yeah, by the way, we're liable.
They're totally passive.
Doesn't mean that if you approach them and say, hey, that's your property that you were charged with the well-being of the property itself, it has been damaged. I, as the beneficiary, am looking for recompense of the property that I had. Where is it? You were charged with this, So, again, state will never step up, and the insurance company will never indicate that the state has any obligation or liability, because it's because of the state's legislation that the insurance companies are benefiting from a law that says you have to have insurance. So the insurance companies are making off like bandits. So you think they're going to point the finger and go, oh, actually, they're liable. Not going to happen.
Testing.
Jack, you mentioned earlier, about purchasing something with lawful money, and, at the risk of going too far down a rabbit hole here, Let's say you do buy a vehicle, you pay cash, you get the MSO, you own the car, blah, blah, blah. Doesn't there still exist this hypothecated lien that the Federal Reserve has because you paid with Federal Reserve notes?
Here's the beauty of that. There's two different types of exchanges you could do with the car at that moment. You could take that MSO and the property and place it into a private express trust under the common law where in exchange what you're going to receive is a certificate of capital interest. Okay, so now private money was used to purchase that car, right? Or you could sell it for silver. And the person purchasing with the silver now has a allodial title to the vehicle. But you're going to want to have one more transaction in there because that breaks the chain of title of any interest the Federal Reserve may have had in the property. Because if you're holding the MSO, that's the evidence of title. Okay? And then when you place both the property and the title into a trust and receive something in exchange, you've severed the tie between that property and the Federal Reserve. You see?
The only problem you're going to have using the silver is if they challenge it and come back and say, and what did you purchase the silver with? Because if you purchase silver or gold with Federal Reserve notes, you still only have equitable interest in the silver and gold. But there are ways...
And that's why all the silver you purchase should go into a trust.
And it should be documented
and then you receive the certificates of interest from the trust, and then the trust uses the silver.
Okay, so there's ways. It's not what you do, it's the way that you do it that affects everything.
Yeah, and we're going to... I want to describe for you guys this weekend a lot of uses of contract in understanding security interests, perfecting security interests is really important for protecting. You want to protect assets, you want to protect your property, you want to protect your well-being, you want to protect your rights. There's interesting, very effective things you can do through contract. You know, like I've been telling people, you don't want to put, it's not so much that you want to put property into a trust, you want to put the security interest in property into a trust. Because the security interest in the property can be much more valuable than the property itself. See, and if, let's say you have a piece of real property, real estate, and all you have is the equitable interest in it. Well, what good is that equitable interest to the trust? It's not worth that much. They've got a beneficial interest in it. However, if you had a $7 million lien on the property, a private commercial lien that was registered on the UCC, that being exchanged into the trust is much more valuable for the trust. And why is that? What does the lien holder have over the property? Control. You've now put control of the property into the trust. Much more powerful than putting equitable interest into the trust.
One more question about that same vehicle that hasn't been registered and you file it on the UCC3. Could you take that filing number and make a plate with that filing number?
First it's registered on a UCC1.
On the UCC1.
Okay. You register interest on a UCC1.
Right.
You assign, amend, or terminate interest on a UCC3. Okay? So you got to remember that's the distinction between the two forms. So if you registered your interest on the UCC1, that's like your private registration of the vehicle.
Okay.
Now, at this point, though, if we're still talking about the same vehicle,
right?
Okay, the problem with that is somebody else is holding the legal title to it.
So you still got to get that back.
Yeah, you got to see if you'd have done what Robert said. You paid for the car up front, and you got the MSO, and then you registered that MSO on a UCC1. You can create your own plates and everything, and you've got a registered claim to the vehicle. And what's the police officer going to do when he runs your VIN number? Nothing's going to come up. He's going, oh, well, I guess that is your vehicle.
Unless it's presumed stolen.
No, actually, if the VIN number isn't in the system, To them, it's property that they don't have any jurisdiction on. But as soon as that VIN number makes it into their computers, even if you've changed the license, you've endorsed it, the certificate, everything else, it appears in their system as property of the state.
Has control.
Yeah.
But right now, if you were to do something with a UCC1 on that number, you could be charged civilly and probably even criminally by doing something to lien somebody else's title interest in property that you've never paid for, and that could be turned into a criminal charge. So you have to understand what you're doing.
Which doesn't mean you couldn't handle that too. Because we handle those all day long too. Because those just really criminal charges what?
Civil charge on steroids?
It's commercial. It's commercial transaction, that's all it is. Now, I don't advise all of you to go get yourselves involved in criminal transactions. But if you're on the fast track of learning commerce, that's a good way to get on the fast track. Because you will be committed at that point to learning this stuff. Well, maybe, I don't know, because I've seen guys who are in jail and are facing huge criminal charges and still not that committed to learning this, to helping themselves out. Haven't you experienced that, Jack?
Oh, absolutely, all the time.
I mean, it's really remarkable.
All right, 2 questions. First question: what is the success rate on getting back the MSO from the state once it has already gone through?
Yeah, I don't know if I've known anyone who's done that. I know people who've gotten it at the beginning.
Okay.
I don't know. I may have heard it once from someone, but I'm not recalling right now anyone who specifically got the MSO back from the state.
If it was a brand new vehicle and you go in and you can satisfy the company that you're paying cash or whatever for it, so that they're not worried about providing a security lien, all you have to do is tell them that you're removing the property from this state, and then you're entitled to the MSO. What you do with it then, because you're basically saying you don't want to register it in this state, you're taking it away to a foreign state. And they've got to give you something, so the MSO on a brand new vehicle is what they turn over to you.
Well, probably what then they'll do, what state are you sending it to, we'll send it to them for you. That's probably what they'll
try to do. Give them address. No biggie.
Or tell them that you're selling it to someone in a foreign country.
Okay. And then another real quick question. Since most of our vehicles are imported, wouldn't the VIN numbers be already automatically registered to their destination, port destination?
The VIN numbers are registered in manifests, okay?
Okay.
But those manifests don't become part of a state's claim to the vehicle. What gave the state a claim to the vehicle was when the car dealership sent the MSO to the state.
Gotcha.
Then they registered it. So even getting it back, that VIN number is still in their system. It'll never be out of their system. Even if you've gotten rid of the title, taken it to another country, whatever, that VIN number is in their system as we have an interest in it. Because in reality, they never terminate their interest in it. See, there's termination of interest and there's assignments of interest. What do you think the difference is? Termination relinquishes. What does assign do? To my interest. If I'm assigning Jack an interest in something, what happens to my interest? No, it's still there. I still have an interest. I've just assigned an interest to Jack. So now who has an interest? Me and Jack. If you notice, have any of you ever used the electronic UCC filing system? Okay? You do a UCC1. You register your interest in a piece of property. Then you do a UCC3 assignment on that property. And then you go and look at the transaction breakdown of that UCC1 number, and what's it list for secured parties and debtors? It lists both the original register and the assignee as secured parties on the property, because both parties have an interest. So just assigning your interest isn't relinquishing. A termination of interest is a relinquishing of interest. So I would have to assign my interest or sign an interest and terminate my interest, which then Jack would file a UCC1 and he would list me as the assignor because my interest was terminated. Or he would just file a UCC-1 and not list any assignor. He doesn't have to.
Well, then you could probably, can't you compel then the state to terminate the interest completely and remove from the database, and they don't remove it?
You may be able to.
Somebody mentioned earlier with the deed. See, what happens in like a warranty deed is you transfer or register that warranty deed with the county. Then the county actually sends you back the canceled warranty deed, which in reality is the certificate of title, because the title's transferred by the registration. Okay? How many people ever do an acceptance, which is basically a return of the certificate? And until you do that, you don't have title. Okay? So really, the certificate of title to the car, you're actually doing the signature off and the return, but like Brandon says, it's usually at the last 5 minutes of ownership of the car. What would happen if the state sent you the certificate of title and you decided you wanted to claim that car without the state's interest? You got to do an acceptance of that certificate of title, which is really the cancellation or termination thereof.
And the reason why I'm making a point about the registration of those VIN numbers is because there's a gentleman in California who's done this process of getting the MSO, registering his interest on a UCC, never registering it with the state, created his own private plates, registers the car's interest on the UCC in the name of an entity like a trust, and then whenever he gets pulled over, he goes, "This is in my vehicle. Here's the registered interest in it," because it's got private plates on it. The cop's running the VIN number, doesn't show up in his system, and he goes, "All right, have a nice day." Because the cop realizes he has no jurisdiction over the vehicle because the VIN number is not listed anywhere. Now, if he had private plates and that VIN number came up on the police officer's computer system, what's the presumption? Not to say you haven't done a proper process to get the title private, but what's the officer's presumption? The state has an interest in that you're pulling some funny business. You're trying to avoid something. Okay? So that's why I've made a point of bringing that to the foreground of that VIN number and getting that original MSO at the beginning and never getting that VIN number registered into the state system.
The larger point of what we've been trying to emphasize this morning on doing foundation is that you're already involved in so many background contracts or trusts, you have no idea really of what these things are. And so you meet a law enforcement officer or some Tom, Dick, and Harry that comes to you with an offer, and you think you can just say no and walk away without understanding that probably the guy that's coming to you with an offer understands that there is a background obligation here somewhere, and you better look into what it is that you may be involved in before you just say no. Because the issue is, the straw man probably has some duty there, and the way out of it isn't to get into an argument with these people. It's really to look at the guy that comes to you and say, well, what are you interested in? How can I help you? Well, I need $3,500. Well, let me write you a check, and then you can go on your way. Have a nice day. That's basically what you're going to do with most everything that approaches you. Now your problem in your mind is, where am I going to get the funds to write the $3,500 check? And now you've got to understand what is available as resources to you when you're thinking in the mindset that if somebody's coming to you with a problem, somewhere down the line, if you've got a duty and an obligation, what role were you playing that gave them that right? We assume it's a trust. There's only 3 parties in the trust. If somebody's coming to you and trying to get a claim against you, IRS, the law enforcement officer, your landlord, a business partner, What is it that they assume somewhere in the past you acted in some capacity in a trust? What capacity do you think they know you were acting in? Grantor. And now they want you as a trustee to do something. You understand? Well, if you are the grantor, didn't you give the rights? Absolutely. So what do you have to do to be able to keep those rights? Resolve any problem resulting from the contracts that you gave out there. If you pay off all the claims, you're still the big chief. But if somebody brings a claim against that trust and you don't settle that claim, then that trust has got a permanent lien against it, and you got all kinds of trouble with the collateral in that trust, which is the property, until you pay it off. Now, you're going to go, but I'm a beneficiary, I can't pay. Well, remember, before you were a beneficiary in the trust, what were you? The grantor. So you got to go back to the role in which you had the authority and the power. You never take on the role in which you only have duties and obligations. So you got to understand you wear a lot of different hats. And depending upon which hat you're wearing in this process is going to determine whether you're going to come out good or bad.
Okay. Any more questions before we go to break? Well, we have one right here. Go ahead. John, go ahead.
In regard to the car situation, I own all my cars, and they're all in LLCs. Mm-hmm. But they are, and I have all the titles.
So do you own them?
Well, no, the LLC does. But they are all registered as well.
Okay.
Okay, so what title do you have? Equitable, legal, or both?
Well, I think equitable at this point.
Yeah, the LLC has equitable,
But
so it can really use and possess it.
Now you said that, so there's no bank interest, right?
Right.
Okay, now here's an interesting scenario and contract situation that would put you in a place of having control over the vehicle. Okay? A contract whereby the LLC becomes obligated, and let's say the amount of the obligation is 3 times the value of the car. The party in which that LLC is obligated to has a contract where the car is the collateral on that debt and registers itself with the state as the lien holder on that. You ever seen certificate of title when it gets printed up? Little box that says lien holder on it? So the state is only legal title holder when, Jack?
When it's holding a claim.
When it's holding the claim, or when there's the presumption that there isn't another party with the claim. So for instance, when your vehicle, when you financed a vehicle and your title has lien holder on it, Bank of America, is the state the one who's going to take responsibility for controlling that vehicle? No. It's up to Bank of America. And can the state take that vehicle and auction it? You know, you hear about drug dealers getting their cars taken and then the state auctions the vehicle, right? But what if there was a lien holder on that vehicle? Could the state auction off that vehicle? No. It'd have to go back to the lien holder, wouldn't it? Shh. Okay? So you see, the lien holder becomes the controlling title holder. But that's one little contract that could change your relationship and your control over your vehicles.
But since the lien holder has it registered through the state is still used as the front for the rules for the use and operation of the car and all this happy jazz. So the state still has some controlling interest. But in terms of the equity, if the state tried to do a forfeiture on it, the first lien holder in most cases is going to get paid out the equity before the state takes it.
So if the obligation is 3 times the value of the car, that's fine. I'm still getting, the lien holder is still getting or has that interest. Okay. Now typically what you'll see is they won't even auction it. You know, they realize we're not the ones with controlling interest in this vehicle. The lien holder has a controlling interest. Lien holders have control over property, especially if you're first in line, first in time lien holder. Because for one, the state stands in the background with their interest. They don't come out and tell anyone, we've got legal title over all your property, do they? Nor do they exert that.
A state senator once said that, but it's not widely publicized.
Yeah, but they don't want to give that impression to anyone. So they'll never step up to the foreground and say, we've got to control. So if some other lien holder is there and says, whoa, 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 what are you doing? I have a lien on that vehicle. Do not sell it. What's the state going to do? They're not going to sell it. Because they can't step up and say, well, no, we actually have the legal title. When he registered it, we took legal title. We're holding the MSO. And then everyone goes, wait, what?
See, a trust...
It would have everyone doing a double take and reconsidering, like, what is really going on here between me and the state? And the state doesn't want to give up the game. So they're never going to step forward and say, we've got legal title.
A trustee cannot convert the equity in the property of the trust without being in violation of the trustee rule that he only controls the property and gets no direct benefits out of the property. So if the state wants to sell the property like at a forfeiture, they stand in the same position of every other equitable interest party in the trust, even though the state itself has the MSO and it's got legal. But as a trustee, the trustee can't say, well, there's a diamond in this estate and my wife would really like that diamond, I'm going to take it. The trustee could be arrested and thrown in jail for converting the assets of the trust, which are there in equity. So if the state wants to take the equity, they got to stand in line like every other lien hold claimant to the equity.
Mm-hmm. And if you were first in line, first in time with your lien, everyone's behind that.
Well,
that's being a creditor, isn't it?
That's the position of best authority as a creditor instead of a debtor. Remember, it's control everything, own nothing. The way you control it is you have a security interest instead of a title.
Let me ask you this. If there were a trust, and that trust had an, let's say, an interest, or you had an obligation. Let's say your straw man, Miss Mary Soko's straw man, had an obligation to a trust. And that trust, in turn, put a levy on her wages. And informed the employer that Miss Mary Soko has a $7 billion obligation to us. You're going to send every penny of her paychecks to us. Through her agreement, she's agreed to have 100% of her wages levied, but we have the interest in those wages. Could anyone else ever come in and levy those wages? Nope. And then let's say that trust who's receiving all of her wages because she's just a regular W-2 employee. She works at Kentucky Fried Chicken, you know, and so all the wages are going into the trust. Now what? Now Mary, over here not getting any wages, is really hurting. Needs to pay for her house, needs to pay her bills, needs to buy food, needs to pay for her car. So what she does is she turns around and she borrows money from the trust. When you borrow money, is that a taxable event? Nope. And now she's going even deeper in debt to the trust, which is now going to list all of her property as collateral to the debt that she has. So she just keeps borrowing money from the trust. And as she borrows money, her obligations and debts to the trust go up. And the trust is the one, now the trust is putting liens on her car, so now the trust is the lien holder on the car. Now the trust has a levy on her wages, has a lien on her car, has a levy on her accounts. Who has all the control here? The trust. Oh, and did I mention that it's a private contract express trust under the common law, which is outside the jurisdiction of any public entity. So who can challenge the trust? Nobody, except the parties of the trust.
In essence, he just described the United States of America doing business as U.S., or he described you understanding how you can set up your affairs and do business in the same way. Makes no never mind.
And believe me, I'm not an innovator, and this isn't something that only I know. All the wealthiest people in the world know this model. They operate under this model. They know how to separate all liability. They know how to control all property. And none of them holds any kind of equitable title in anything. So it's not new. It's an old model. But if you understand it, you can be very powerful and effective in commerce just with a little bit of knowledge and a few contracts.
My son owes the IRS, I don't know, $6,000, and he owns a car.
Straw man owes the
His
IRS.
straw man. His straw man also owns a car outright with no lien on it. So I think you've already answered this, but would the protection be for him? We were going to title the car over to me, and I was going to insure it, and then he wouldn't have to worry about it.
Why are you evading and avoiding? Why didn't you learn how just to pay off the tax man and let the problem?
See,
Well,
the best way to approach this, for those of you who don't have levies, liens, and debts to IRS or any other entity, that's the time to put the contracts in place. Okay, because really what you're talking about is what the IRS would qualify as fraudulent conveyance. Okay? So you don't want to get involved with fraudulent conveyance. However, if there were already a contractual obligation in place, you wouldn't have anything to worry about. So,
Okay, take about a 15, 20-minute break.
You're welcome. Thank you.